these opinions indicate where the doubt and uncertainty may be. On the other hand, Willoughby, in his work on the Constitution, makes the positive statement that the naturalization of a father operates as a naturalization of his minor child if they are dwelling in the United States. We find the positive declaration of the court that the citizenship of the father is that of his child. There is no dispute on the facts that the father in 1862 was an English subject. There can hardly be, under the law just quoted, any dispute that Mr. Hughes was at the time of his birth an English subject. If he was at that time an English subject, he became a citizen of the United States by a process of naturalization, and is not a natural-born citizen of the United States. He became a citizen by virtue of the subsequent act of his father. He became a citizen by operation of law, but he was not at the instant of birth, by right, and of the nature of things, a natural-born citizen of the United States. And Willoughby, further on, says, a declaration of a father, of an intention to become naturalized, gives to his children, who attain their majority before their father's naturalization is complete, an inchoate citizenship, which, upon majority, may be repudiated. These point clearly to the fact that the child of unnaturalized parents is an alien, and that he becomes a citizen by virtue of the subsequent act of the father. That is, that the child is a naturalized citizen, that he becomes a citizen by operation of law, and that he is not a natural-born citizen within the meaning of the Constitution. It might be supposed that the statute above quoted applies to children born in foreign countries and brought to the United States by the father. A careful reading of the statute will permit of no such discrimination. And directly on that point is a document written by Mr. Fish, when Secretary of State, under the date of February 11th, 1874, in answer to an official inquiry. The document reads as follows. The laws of the United States on the subject of naturalization provide, in relation to persons situated as your sons are, that the children of persons duly naturalized under any law of the United States, being under the age of 21 years, at the time of their parents being so naturalized or admitted to the rights of citizenship, shall, if dwelling in the United States, be considered as citizens of the United States. Assuming that your 3 sons were born in France, accompanied you to this country, and have continued to reside here, they, together with your son, born here, are, under the provisions just cited, to be considered, when dwelling in the United States, citizens of the United States. It will be noted that the eminent Secretary of State not only drew no distinction between the children born abroad and the child born here, but that he included all together in the same category, and as to be considered, when dwelling in the United States, as citizens of the United States. What would happen if they did not dwell within the United States? What would happen if the father took them back to the country from which he emigrated? Under the statute and under the opinion just cited, interpreting the statute, they would, in that case, not be citizens of the United States. And if they were not to be considered citizens of the United States when they left the boundaries of the United States, how could they be natural-born citizens of the United States? Who would owe allegiance to no other power, and who would have a right to the protection of this government, no matter where they might find themselves? The Supreme Court of the United States has construed that statute and the Constitution, and has passed directly on the point in issue. It has said that one born of alien parents in the territorial limits of the United States is not a natural-born citizen within the meaning of the Presidential Qualification Clause, and further said that such persons, not being citizens, can only become citizens by being naturalized in the United States. Elk v. Wilkins, 112 U.S. 94. Such naturalization can be accomplished by the son on his own account, or through the subsequent act of the parent. Mr. Bline, as Secretary of State in an official document to the United States Minister to Germany, again under date of February 1, 1890, construed the law, pointing out the status of the child if it left the United States. The facts in that case were as follows. A husband and wife, both natives of Prussia, came to the United States. A son was born in the state of Pennsylvania 6 months before the naturalization of the father. Later, the father died, and the mother returned to Germany, taking her son with her, and they were residing in Germany at the time of the inquiry. While in Germany, the government made some claim upon the son for military service, and the ruling was requested from the Secretary of State. Secretary Bline wrote as follows. The words, if dwelling in the United States, whether meaning residence at a particular moment or contemplating a settled abode, apply to Karl Hassinger, who, being now 19 years of age, has for about 11 years been dwelling in Germany. It is not known that the government of that country has made any claims upon him. But if the German government should, under a provision of law similar to that in force in the United States, in relation to the foreign-born children of citizens, seek to exact from him the performance of obligations as a natural-born subject, the department would be bound to consider the provisions of Section 2172 of the revised statutes. Mr. Bline's reference to Section 2172 of the revised statutes means that this government would recognize that child as a citizen of the United States if he lived in the United States, but would not recognize him as a citizen of this country if he lived in Germany. Was that boy a natural-born citizen of the United States? If he was, then why would not the government of the United States recognize him as a citizen of the United States, whether he were in Germany, England, or China? The only conclusion is that he was not a natural-born citizen of the United States. That some other government beside that of the United States had some claim upon his allegiance. That he was not exclusively, and by operation of the laws of nature, a citizen of the United States. The boy that Mr. Bline referred to in the above quotation was not only born in this country, but born to a male parent who had not only expressed his desire to become an American citizen, but who had proceeded to perfect his naturalization, and who actually was naturalized 6 months subsequent to the birth of the child. The rulings under the statute hold that the child became a citizen of the United States by virtue of the naturalization of his father, but that his citizenship during his minority was only inchoate, and that if he continued to reside in the United States, he would be recognized as a citizen of the United States, not a natural-born citizen. But that if he went to Germany, he would not be, by our government, considered one of its citizens. How does this case differ from that of Mr. Hughes, excepting this: that Mr. Hughes and his parents continued to reside in this country? Their domicile affected his citizenship. Had they taken him back to England, he would not have been considered by the government of the United States as a citizen of the United States. The mere circumstances that he continued to live here, and, upon the attainment of his majority, to exercise his political rights, perfected the inchoate citizenship which he inherited by the naturalization of his father. Only from the time of the actual naturalization of his father was he considered to be a citizen of the United States, and only upon the adoption of the 14th Amendment did he actually become a citizen of the United States. But what was the status of that boy at the time of his birth and immediately following his birth? The government of England might have exercised jurisdiction over him. That government had some claim which, under certain conditions, it might have been exercised. Had he been a natural-born citizen of the United States, no government on earth but that of the United States would have had any claim upon his allegiance. The law of England, at the time of his birth, was, once an Englishman, always an Englishman. Not until 1872 did England change that law.